In this video, we're going to discuss contract law. On the state exam, this section is very important to remember. So, I brought a special guest today to help us out. This is a good friend of mine, Randy. Randy is an attorney that specializes in contract law. Randy, thanks for being here today.
Thanks, Ernie.
To begin, we have to understand what a contract is. Randy, what is a contract?
In its simplest terms, a contract is an agreement between two people or two parties. They don't necessarily have to be people. You can have a contract with corporations. But in its simplest terms, it's an agreement between two persons or parties to do a certain thing, an act for an act.
Perfect. Now, what are the essentials to a contract? Pay attention.
This is important. It's on your test. I remember it when I took my test. The essentials to a contract are offer. I'm going to make you an offer to do something. Acceptance. You're going to accept my offer. And consideration. Consideration is I'm going to give you something of value in exchange for something of value. In the real estate world, you're probably talking about a house or a condo. That's the piece of value you're giving me, and I'm giving you cash. That's consideration.
Now, do these contracts have to be in writing?
For the purposes of real estate, contracts have to be in writing. If you're buying or selling a home, it must be written. There are some other elements of a contract in real estate, specific to real estate. It must be signed by the party to be charged. The party to be charged is the person entering into the contract that you expect to perform. And you have to have a proper legal description. So in writing, legal description, and it must be signed by the party to be charged.
Perfect.
One of the other elements, and I will just continue,
Yeah.
It's probably on your test, meeting of the minds. Meeting of the minds means you and I have the same idea about, or a very similar idea about what our transaction is going to entail. And most of that, at least in real estate, you're going to come with a pre-printed list of stuff on a pretty long contract form. And those contract terms are intended to help us get to the meeting of the minds. It asks you all kinds of questions about when do you want to close? How much do you want to pay for this property? How much are you putting down? What happens in the event of a breach? Those forms are intended to help you come to that meeting of the minds. And it also, the contract also performs the other function of a writing to be signed, and there's going to be a line on your contract for the legal description of the property you're talking about.
Perfect. Thank you very much. Now that you know what a contract is and the essentials, now you have to know what the 6 classifications are. Unilateral, bilateral, express, implied, executory, and executed. Those are the 6 classifications you have to know. Randy, what does a unilateral contract mean?
The best way to describe a unilateral contract is to describe it as an option. Ernie, I will allow you to buy my home for $100,000 if you agree by next week. I'm offering him, would it still have to be written, remember, but I'm offering him an option to purchase my item for a specific price if he chooses to execute it. I can be bound to that contract if it is otherwise enforceable. He cannot be bound. He does not have to buy it. So that's the best way to think about a unilateral contract.
Perfect. Randy, what's a bilateral contract mean?
Bilateral contract, the easiest way to think about that is in the real estate world, it's typically how it works. You write an offer to buy my home. I accept it by sending you the acceptance back. It's a promise for a promise. Once we're under contract, we're both bound, but think of it as promise for a promise. We both agreed to do something, and we can both be bound by that decision.
Perfect. How about an expressed contract?
Express contracts are simple. They're written. There's something that's specifically delineated, usually on paper, usually written.
How about an implied contract?
Implied contracts are different from express contracts in that they are not express in terms of being written. The easiest way to think about an implied contract, think about a tenant who has a 1-year lease. At the expiration of that lease, they stay in the house for another month. The landlord accepts another month of rent. They're probably under an implied contract. Technically, their written agreement has expired, but they keep doing the things that they otherwise were doing. So it's implied that they're going to still be bound by the same original contract and the terms therein.
Perfect. What's an executory contract?
An executory contract is a contract that, the easiest way to think about this one in a real estate context is if it's in escrow. You've got the major terms, you've got them on paper, things are started, but it's not been performed yet. Neither side has performed. And in the real estate world, I haven't given you a deed for my house, and you haven't shoveled the money into my bank account.
So basically, it's in the process, right?
You can think of executory as being in process, correct?
Perfect. Okay. Last one, Randy. What does executed mean?
Executed means the deed has been transferred, the money has been transferred, everything's done.
Perfect. Now we know what a contract is, the 6 classifications. Now we have to know what the status of a contract is. There's 5. Valid, void, voidable, unenforceable, and enforceable. Randy, what does a valid contract mean?
This is the easiest one to remember. It's a valid contract. It has all of the elements. All of the elements are satisfied. That's it. It's
Pretty
valid.
easy. Pretty easy.
Easiest one.
All right. What does void mean? A void contract.
Void means, for whatever reason, it may be operation of law, it is not a valid contract. It is the antithesis of valid contract. It cannot be enforced. It's not a contract at all.
Perfect. Okay. What does a voidable contract mean?
Voidable typically means one side can enforce it, the other can't. The easiest thing to remember, the easiest way to remember it, for instance, in Arizona, the legal age to enter into a binding contract is the age of 18. So if I'm 17 and I enter into a contract to sell you my home, you can't enforce it against me because at the time I entered into that contract, I was unable to contract with you legally. I might be able to enforce it against you, but you can't enforce it against me. It's voidable as to one of us, not as to the other. We could go forward, we don't have to.
Okay. What does unenforceable mean?
The best way to think of unenforceable is to think about the difference between unenforceable and enforceable. Unenforceable, I cannot drag you into court to make you do what this contract says we're going to do. It could be unenforceable for a number of reasons. Enforceable means I can take you into court and the judge could order us to do whatever our deal was.
Great. Lastly, we have to know what a breach of contract is. Unfortunately, some of these contracts go south. So Randy, please enlighten us on a breach of contract.
In its simplest terms, a breach of contract means one party to the agreement didn't do something they were supposed to have done. For instance, in a real estate, I'm going to buy your house. As part of my offer, I'm going to deposit with the escrow company some earnest money. If I fail to timely deposit my earnest money, I have potentially breached the contract. So one party doesn't do something that they're supposed to do. You can have cases where both parties don't do what they're supposed to do.
And can somebody sue for specific performance? And if they can, what is that?
Specific performance is when I ask a judge to force you to do the very thing that you were supposed to do. In certain circumstances in the real estate world, yes, you can sue for specific performance. An example you might think about, I'm going to buy your house. We're under contract. We're getting close to close. Ernie gets very emotional about his properties. So he decides one day, I don't want to sell you that house anymore. I know, Randy, you've done everything you were supposed to do. You've got the money in escrow. You've signed all your documents. But darn it, I don't want to sell that house to you anymore, and I'm not going to sign my documents. That's an example of a breach of contract that I could sue Ernie for specific performance. I could go into court, ask a judge to force him to sell it to me.
Great. Well, that concludes this segment. I want to thank Randy for taking the time to help us out today, and we'll see you again soon.